Welcome back, everybody, to the Zachary Gale Experience 369. I'm your host, Zach. And today we're going to be doing something special. I'm going to be reading the United States Constitution from 1787. So, I got this Constitution from Young Americans for Liberty. I'm going to go ahead and read what Young Americans for Liberty is. It's just a page. So America was founded to protect the individual rights of life, liberty, and pursuit of happiness. Unfortunately, since its conception, the ideas our founding fathers set forth have slowly eroded away. Corrupt politicians have expanded federal government power, waged unconstitutional wars, and squandered our national resources. The nation's founding documents, the U.S. Constitution, has been reduced to nothing more than a piece of paper. Nowhere is the shift away from constitutional thinking more prevalent today than on America's college campuses. Agreed. Statism has found a home in the ivory towers of academia. Biased professors and political correctness dominate what is supposed to be a bastion of debate and freedom of speech. American campuses have unequivocally become de facto indoctrination camps. Wow. As with all overbearing policies, there is a breaking point, and the oppressed being will begin to lash out against their oppressors. For many young people, this breaking point hit during the Ron Paul 2008 presidential campaign. The students for Ron Paul efforts applied youthful energy and organized over 500 campus groups and recruited over 26,000 students to the campaign. At the end of Congressman Paul's presidential race, the energy was immense, and young people demanded an avenue to continue their work. As a result, Young Americans for Liberty was born. Using the vast students for Ron Paul Network, Young Americans for Liberty has become the biggest and loudest voice for liberty on American campuses. Hundreds of YAL chapters and thousands of YAL members comprise this youth organization. Newly forming chapters and additional recruits join the youth movement for liberty every day. As Congressman Paul has said, freedom is popular, and YAL is shining proof of the fact. Let it be known that we did not arrive at this precarious point in history overnight. Instead, it has been through a slow incremental process that government has taken control over our personal lives. Solutions to our nation's problems will not happen instantaneously. They will take time, hard work, and a commitment to the Constitution. But we can restore this great republic. It is the next generation that will bear the greatest burden of government and must face the challenges ahead. There's a little bit more on the other page. I'll try and finish this up, sorry. YAO is prepared for that fight. We will lead a youth movement to change the direction of our country. To reach our goals, not only is it important to educate our fellow Americans on the principles of liberty, but we must also elect principled statesmen to office. Young Americans for Liberty seeks to educate our members on the ideals of liberty and train them in strategies and tactics to advance our message in the political process. So, as stated in our mission, YAO is committed to winning on principle. Young Americans for Liberty is a network of like-minded individuals receiving exceptional political training as they find their voice in the fight for freedom. Please visit YAL website, www.yalliberty.org, join our effort, start a chapter, and make a difference in the direction of our country. For Liberty, Jeff Fazey, Executive Director of Young Americans for Liberty. So shout out to Young Americans for Liberty. I actually got this on campus at some point. I have not joined their club, but I did not realize that they like Ron Paul so much. So, there's a foreword by Ron Paul. Another page. I looked at the Constitution and I saw that there was a Constitution, but I didn't expect to be reading this part. So please forgive me. But I like Ron Paul, so he is very constitutional. So I think it's very valid to read this recording. So a foreword by Ron Paul. The Constitution is a revolutionary document. It is also a perfect illustration of how freedom brings people together. The delegates of the Constitutional Convention in 1787 had to draft a charter to limit government and secure liberty for Americans of all kinds, farmers and industrialists, Christians and deists, Yeah, I think that's how you say that. Big states and small states. Nothing but freedom could overcome the division and work for everybody. The Constitution was not perfect. It allowed for slavery at first, lacked a Bill of Rights. The framers argued that the divided and limited power enumerated in the Constitution were enough to protect our rights. The Anti-Federalist opponents of constitutional ratification, like Patrick Henry and George Mason, warned that the president and the federal courts would be too powerful without additional safeguards of liberty. The framers were very careful not to give the president or the courts the most dangerous powers that government has. They only entrusted the power to declare war and to raise taxes to Congress. See that today that they are not following that. Where was that? Oh yeah. Declare war and raise taxes to Congress, the branch of government most directly answerable to the people. And after the Constitution was ratified, a Bill of Rights was added to forbid any branch of the federal government to interfere with liberties like our right to free speech, to the free exercise of religion, and to keep and bear arms. These guarantees of freedom brought the framers and the Anti-Federalists together in support of the Constitution once it was adopted. Strictly limiting government was a revolutionary idea. What was even more revolutionary was that the Constitution left the most important things in life, like religion and education, free-form government control. The framers knew that no government, no matter how carefully designed, could make people virtuous. That job belongs to families, churches, and communities, not politicians and government schools. Wow, powerful words, Ron Paul. Right from the start, however, politicians were unhappy about the limits the Constitution placed on them. Even Thomas Jefferson, as president, overstepped his constitutional authority by buying the Louisiana territories. Alexander Hamilton succeeded in creating a national bank without constitutional authority to finance government and centralize economic power, which is actually unconstitutional. Politicians damaged the Constitution not only by violating its letter, but also by ignoring the wisdom that created the Constitution in the first place, creating taxes and tariffs that hurt some parts of the country more than others. Just as freedom brings people together, the opposite of freedom, tariffs, wars, and slavery tears a country apart. Since the Civil War, Washington has done everything that the framers tried to prevent, from letting the president make wars to interfering in religion and federalizing education. But the people still want freedom. They want a revolution to return to the Constitution. Americans for Liberty is leading the way by educating people about their rights and demanding that politicians obey the Constitution. That is why I hope you read the Constitution carefully and take the time to join YAL and Liberty, Ron Paul. Excuse me, former Congressman Ron Paul. Alrighty, now to the actual Constitution. The Constitution of the United States of America. A preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our prosperity, to ordain and to establish this Constitution for the United States of America. Article 1. The legislative branch. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2 of Article 1. Part 1 of Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. Part 2 of Section 2. Excuse me. No person shall be a representative who shall not have attained to the new age of 25 years old and been 7 years a citizen in the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Part 3 of Section 2. Representatives and direct taxes shall be appropriated among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed. 3/5 of all persons. This is modified by the 14th Amendment. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the new state of New Hampshire shall be entitled to choose 3. Massachusetts 8, Rhode Island and Province Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority, this is part 4 of Section 2. When vacancies happen in the representation from any state, the executive authority there shall issue writs of election to fill such vacancies. Part 5 of Section 2. The House of Representatives shall choose their speaker and other offices and shall have the sole power of impeachment. The Senate. Section 3, Part 1. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof. This is also modified in the 14th Amendment. For 6 years, and each senator shall have 1 vote. Part 2 of Section 3. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the second class at the expiration of the 4th year, and the third class of the expiration of the 6th year, so that 1/3 may be chosen every 2nd year, and if vacancies happen by resignation or otherwise during the recess or the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. Also modified by the 14th Amendment Clause 2. Actually, the 17th Amendment. Sorry, and the other one was the 17th Amendment when I said it in Section 3. Sorry. Roman numerals, man. Section 3, Part 3. No person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state for which he shall be chosen. Part 4 of Section 3. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. Part 5 of Section 3. The Senate shall choose their officers and also a president pro tempore. In the absence of the vice president, or when he shall exercise the office of President of the United States. Part 6, Section 3. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried The Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Part 7 of Section 3. Judgment in cases of impeachment shall not extend further than to removal from office, and disqualification to hold and enjoy any office in honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable to subject to indictment, trial, judgment, and punishment according to law. Rules of Congress, Section 4, Part 1. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by their legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places or choosing senators. Part 2 of Section 4. The Congress shall assemble at least once in every year, and such meetings shall be on the first Monday in December, modified by Amendment 20, unless they shall by law appoint a different day. Section 5, Part 1. Each house shall be the judge of the elections, returns and qualifications of its own members, and a majority of each shall constitute a quorum, Quorum, I'm not sure if I pronounced that right, shall constitute a quorum to do business, but smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner, and under such penalties as each house may provide. Section 5, Part 2. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. Part 3 of Section 5. Each house shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may in their judgment require secrecy, and the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Part 4, Section 5. Neither house during the session of Congress shall, without the consent of the order, adjourn for more than 3 days, nor to any place other than that in which the two houses shall be sitting. Section 6, Part 1. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses. Wow. So if you have like a minor like thing that wasn't just listed there, you still have to go to attend the session. Where's that? From arrest during their attendance at the session of their respective houses, and in going to return from the same, and for any speech or debate in either house, they shall not be questioned in any other place. Part 2, Section 6. No senator or representative shall, during the time of which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments, Emoluments, I believe it's pronounced emoluments, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office. Continuance in office. Welcome to the stream. Section 7, Part 1. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. And I'm going to go ahead and stop the recording here for the podcast. I will have another version of it, and it should already be up. See you then. Just going to quickly title this. Just give me like 30 seconds. Alrighty. Just give me a second to catch my breath. Alrighty. Okay, here we go. Welcome back to the Zach Agale Experience 369. I'm Zach, and we are going to be reading about Section 7, Part 2 of the Rules of Congress. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, with his objections to the House in which it shall have originated, who shall enter the objections at large on the journal and proceed to reconsider it. If, after such reconsideration, 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become a law. But in all such cases, and votes of both Houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each House respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall be presented to him, the same shall be a law. In like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Part 3 of Section 7. Every order, resolution, or vote to which the concurrence of the Senate and House and Representatives may be necessary, except on a question of adjournments, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. The powers of Congress. Section 8, Part 1. Let's see. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duty, imposts, and excises shall be uniform throughout the United States. Part 2 of Section 8. To borrow money on the credit of the United States. Part 3. To regulate commerce with foreign nations and among the several states and with the Indian tribes. Part 3. To establish and uniform rule of naturalization and inform laws on the subject of bankruptcies throughout the United States. Part 5, and this is the part where the Federal Reserve breaks. To coin money, it says in the Constitution that only Congress is allowed to coin money and regulate the value thereof, and a foreign coin and fix the standard of weights and measures. Part 6 of Section 8, to provide for the punishment of counterfeiting the securities and current coin of the United States. Part 7, to establish post offices and post roads. Part 8, to promote the progress the progress of science and useful arts by page flip, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Part 9 of Section 8, to constitute tribunals inferior to the Supreme Court. Part 10, to define and punish piracies and felons committed on the high seas and overseas against the law of nations. Part 11, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Part 12, to raise and support armies, but no appropriation of money to that shall be used for a longer term than 2 years. Part 13, to provide and maintain a navy. Part 14, to make rules for a government and regulation of the land and naval forces. Part 15, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Part 16, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. Part 17, to exercise legislation in all cases whatsoever over such district, not excluding 10 miles square, as may by a session of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and all other needful buildings. And Part 18, to make all laws which shall be necessary and proper for carrying the execution and foregoing powers of all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Powers explicitly denied to Congress. Section 9, Part 1. The migration or imposition of such persons, such as of the states now existing, shall think proper to admit, shall not be prohibited by the Congress prior to year 1808. But a tax or duty may be imposed on such importation not exceeding $10 for each person. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. That was part 2, sorry. Part 3, no bill of attainder or ex post facto law shall be passed. Part 4, no capitation or other direct tax shall be laid unless proportion of the census of enumeration herein before directed to be taken. Let me read that one again. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. Part 5 of Section 9. No tax or duty shall be laid on articles exported from any state. Part 6 of Section 9. No preference shall be given by any regulation of commerce or revenue to the ports of one state other those of another, nor shall vessels bound to or from one state be obligated to enter, clear, or pay duties in another. Part 7 of Section 9. No money shall be drawn from the Treasury, but in consequence of appropriations made by law, and a regular statement and accounts of the receipts and expenditures of all public money shall be published from time to time. Part 8 of Section 9. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. Let's read that one again. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present annulment, office, or title, or any kind whatsoever from any king, prince, or foreign state. Limitations of state powers. Section 10. Part 1. The state shall enter into any treaty, alliance, or confederation, grant letters of marque, and reprisal, coin money, emit bills of credit, make anything but gold and silver a tender in payment of debts. Let me read this one again. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, underline, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts. Has any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Part 2 of Section 10. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on import or export shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and the control of the Congress. Part 3 of Section 10. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. So all of that was Article 1 of the Constitution. Now, Article 2, the executive branch. Section 1, Part 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term, be elected as follows. Part 2. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office or trust or profit under the United States shall be appointed an elector, retrospective states, and vote by the ballot for 2 persons, of whom at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president. If such number be a majority, and the whole number of electors appointed, and if there be more than one who has such a majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person have a majority, then from the 5 highest on the list, that the said House shall in like manner choose the president. But in choosing the president, the votes shall be taken by states and representatives from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot of the vice president. And this is modified in the 12th Amendment. Part 4 of Section 1 of Article 2. The Congress may determine the time of choosing the electors and the day of which they shall give their votes, which day shall be the time throughout the United States. Part 5. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of the President. Neither shall any person be eligible to that office who shall not have attained of the age of 35 years and been 14 years a resident within the United States. Part 6. In case of the removal of the President from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may, by law, provide for the case of removal, death, resignation, or inability, both of the President and Vice President, declaring what officer shall then act as President. And such officer shall act accordingly until the disability be removed, or a president shall be elected, modified in Amendment 25. Part 7 of Article 1 of Part 7 of Section 1 of Article 2. The President shall at stated times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other annulment from the United States or any of them. Part 8. Before he entered on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will do to the best of my ability preserve, protect, and defend the Constitution of the United States of America. Well, just as United States, but Section 2, Part 1 of the second article in the Constitution says, he shall have power by and with the advice and consent of the Senate to make treaties, provide 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States whose appointment are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper, and the President alone, in the courts of law, or in the heads of departments. And thank you so much for listening. I'm going to start another podcast because this one's getting a little long. I'll see you in the next version. Thanks for listening. Just give me like 30 seconds here. It'll be faster than last time. I'm sorry. Just give me 1 second. My father sent me a text. Almost done, sorry. Alrighty, we are ready. Just gotta breathe really quick. Alrighty, we're ready. Welcome back to the Zach Gale Experience 369. I'm Zach, and let's get into it. So we are at part. Okay, we are at Section 2, Part 1 of Article 2 of the Constitution. He shall have the power, by and with the advice and consent of the Senate, to make treaties, provide 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors. And I already read this part. I'm sorry. I just realized I got to Section 3, not Section 2. I'll finish this up. Other ministries and consuls, judges of the Supreme Court, and all other officers of the United States whose appointment are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper in the United States alone, in the courts of law, or in the heads of departments. Part 3 of Section 2. The President shall have power to fill all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Section 3 of Article 2 of the Constitution. He shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, or extraordinary occasions, convene both houses or either of them, and in the case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministries, care laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 3. The Judicial Branch. Section 1 of Article 3 says, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, and shall at stated times receive for their service a compensation which shall not be diminished during their continuance in office. Section 2, Part 1 says, the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, modified by Amendment 10, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof in foreign states, citizens or subjects. Part 2. In all cases affirming ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction, and all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, and under the regulations as the Congress shall make. Part 3. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trials shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3, Part 1. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act, or on confession in open court. Part 2 of Section 2. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Article 4. The interstate relations. Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and effect thereof. Section 2, Part 1. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed from the state having jurisdiction of the crime. Part 3 of Section 2. No person held to service or labor in one state under the laws thereof, escaping into another shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor shall be due, modified by Amendment 13. Federal to state relations. Section 3, Part 1. New states shall be admitted by the Congress into the Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the jurisdiction of two or more states or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. Part 2 of Section 3 of Article 4. The Congress shall have the powers to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in the Constitution shall be constructed as to prejudice any claim of the United States or of any particular state. Part 4 of Article 4, The United States shall guarantee to every state in the Union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Article 5, Amending process. We're almost to the amendments. We have like another page, and then we're to the Bill of Rights. Article 5, Amending process. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislature of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states, or by convention of 3/4 thereof as one or the other mode of ratification may be proposed by the Congress. Provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clause in the 9th section of the first article. I forgot the little parts are called clauses. Jeez. Who let me graduate school? And no state without its consent shall be deprived of its equal suffrage in the Senate. Article 6, National Debts. First clause. So I'm pretty sure that's what that is. All debts contracted and engagements entered into, therefore, the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Supremacy of the Constitution. Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Clause 3 of Article 6. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers both of the United States and of the several states shall be bound by the office of affirmation to support this Constitution. But no religious text shall ever be required as a qualification to any office or public trust under the United States. That separation of church and state, which certain religions out there do not have. Article 7, ratification of the Constitution. The ratification of the Convention of 9 States shall be sufficient for the establishment of this Constitution between the states so ratifying the Senate. The same. Done in convention by the unanimous consent of the states present the 17th day of September in the year on our Lord 1787, and of the independence of the United States of America, the 12th, in witness whereof we have hereunto subscribed our names. And these are the signers. So George Washington, President and Deputy from Virginia. New Hampshire, John Langdon, Nicholas Gilman. I feel like in the movie Gangs in New York, when they're being drafted to the Civil War, I feel like the guy that's like reading the names of like the people I drafted. I feel like somebody's about to like flip out because I said the name. Nicholas Gilman, Massachusetts. Nathaniel Gorham, Rufus King, Connecticut. W.M. Period. Samuel Johnson, Roger Sherman, New York. Alexander Hamilton, New Jersey. W.I.L. Livingston, David Brearley, W.M. Period Patterson, Jona Dayton, Pennsylvania. Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, THOS period Fitzsimmons, Jared Ingersoll, James Wilson, Gov. Morris, Delaware, G.E.O. Reed. I assume that's George Reed. And back to New Jersey, I am assuming it's William Livingston. Back to Delaware. Gunning Bedford Junn, John Dickinson, Richard Bassett, Jacob Broom. Maryland. D. James McHenry, Dane of St. Thomas Jennifer, Daniel Carroll. Virginia. John Blair, James Madison Jr. North Carolina. W.N. Blount, Richard Dobbs Spate, H.U. Williamson. South Carolina. J. Rutledge, Charles Coatsworth Pinckney. Charles Pinckney. Interesting. Pierce Butler, Georgia. William Few, Aber Baldwin. And to attest is William Jackson, Secretary. And now I'm going to go ahead and end the podcast here. The next reading will be the amendments to the Constitution, including the Bill of Rights, which is a lot of pages. Give me un momento, por favor. stretch going on. I usually stretch daily. Just waiting for the string to reconnect. I don't know if you can see me or not. Okay, there we go. We're back. You just stretch really quick. I used to stretch every day before bed, but now I just stretch at random times of the day. My brother's in Taekwondo and he usually helps me stretch. I can almost do the splits now. We're ready. Let me start up another podcast. Alrighty, we're ready. Welcome back to the Zachary Gale Experience 369, and we are going to be reading the Bill of Rights, as well as amendments to the Constitution. Let's get into it. Following months of debate during the ratification process, those who feared that the proposed Constitution ceded too much power into the hands of the federal government came to an agreement. The proposal to each state for ratification of the new Constitution would happen with the addition of certain amendments. So on September 25th, 1789, the newly formed Congress transmitted 12 proposed amendments to the states for ratification. Though 2 of the 12 were set aside, the 10 that were passed became the Bill of Rights. I'm interested. I'm going to look up what the 2 that didn't get passed were. So the typically amendments have a 7-year limit for ratification. However, since the original 12 proposed amendments were thought too crucial to our founding fathers, no sunset clause was attached to them. On May 7, 1992, Michigan became the 38th state, giving the amendment its 3/4 majority to enact one of the original 12 proposed amendments. Thus, the amendment dealing with congressional pay raises became the 27th Amendment 103 years after its initial proposal. Wow, so one of the amendments that didn't get on there was congressional pay raises. Wow, those bastards tried to increase their pay when they were just starting out. Okay, they probably deserved it back then. The Bill of Rights. The first 10 amendments, parentheses, Bill of Rights, were ratified effective December 15th, 1791. The conventions of a number of the states having, at the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added. Amendment 1. Freedom of expression. Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the rights of the people peacefully to assemble and to petition the government for a redress of grievances. Amendment 2. Right to bear arms. A well-regulated militia being necessary to the security of a free state, the rights of the people to keep and bear arms shall not be infringed. Amendment 3. Housing of soldiers. No soldier shall, in time of peace, be quartered in any home without the consent of the owner, nor in the time of war, but in a manner to be prescribed by law. Amendment 4. Privacy against government searches. The rights of the people to be secure in the person's houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by the oath of affirmations, in particular describing the place to be searched and the persons or things to be seized. Article 5. Rights of the accused. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when the actual service in time or war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, shall not be compelled in any criminal case to be a witness against himself, nor be deprived of life or property without due process of law, nor shall private property be taken for public use without just compensation. Amendment 6. Amendment 6. Rights to a fair trial, including counsel. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and direct wherein the crime shall have been committed, which direct shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the abstinence of counsel for his defense. Amendment 7. Common law trial by jury. In suits of common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. And no fact trial by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Amendment 8. Forgot what 5 plus 3 was for a second. Jeez. Ban on excessive punishments. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments convicted. I think that they should have reiterated on this one a little bit more. Let's see, Article 9, acknowledgement of unenumerated rights of the people. The enumeration in the Constitution of certain rights shall not be constructed to deny or disparage others retained by the people. Amendment 10. Powers reserved by the United States and the people. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Amendment 11. State sovereign immunity. Excuse me. The 11th Amendment was proposed on March 4th, 1794, and ratified on February 7th, 1795. However, the amendment was not announced until 1798 because of delays that occurred in certifying the ratification. The judicial power of the United States shall not be constructed to extend to any suit in law or equity commenced or prosecuted against any one of the United States by citizens of another state or by citizens or subjects of any foreign state. Amendment 12. Combined president and vice president elections. The 12th Amendment was proposed on December 9th, 1803, and ratified on June 15th, 1804. The electors shall meet in their respective states and vote by ballot for the president and vice president, one of whom at least shall not be inhabitants of the same state. With themselves they shall name on their ballots the person voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lines of all persons voted for as president and of all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify and transmit unsealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest numbers of votes for president shall be president, and such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest number, not exceeding 3 on the list of those voted, sorry, I lost my place. Of those voted for as president of the House of Representatives shall choose immediately by ballot the president, but in choosing the president, the vote shall be taken by states. The representation from each state having 1 vote, a quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president, whenever the rights of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, and in case of the death or other constitutional disability of the president, superseded by Amendment 20, Clause 3, the person having the greatest number of votes as vice president shall be the vice president. If such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. Amendment 13, Abolition of Slavery. The 13th Amendment was proposed on January 31st, 1865, and ratified on December 6, 1865. Section 1 says, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have the duly convicted, shall exist within the United States, nor any place subject to their jurisdictions. Section 2 says, Congress shall have power to enforce this article by appropriate legislation. The 14th Amendment was proposed, Article 4, wait. Okay. For some reason, I read the 14 as 16. I was like, huh? So, Amendment 14, Federal Civil Rights Protection against the States. The 14th Amendment was proposed on June 13, 1866, and ratified as requirement for re-entry into the Union on July 9, 1868. Section 1 says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2 says, representatives shall be appointed among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the rights to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, and executive and judicial officers of a state, of the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way obliged, except for participation in rebellion or other crime. The basis of representation therein shall be reduced to the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state, modified by Amendment 26, Clause 1, as well as Amendment 19. Section 3 of Article of Amendment 14 says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Section 4 says, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5 says, but Congress shall have the power to enforce by appropriate legislations and provisions of this article. Amendment 15, Racial Suffrage. The 15th Amendment was proposed on February 26, 1869, and ratified on February 3rd, 1870. Section 1 says, the rights of citizens of the United States to vote shall not be denied or obliged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2 says, the Congress shall have power to enforce this article by appropriate legislation. Amendment 6, the 16th Amendment says, excuse me, see how we're getting on the podcast, okay? This will be the last amendment I read for this podcast. The 16th Amendment says, was proposed on July 12, 1909, and questionably ratified on February 3rd, 1913. The Congress shall have power to lay and collect taxes on incomes from whatever source derived, without appointment among the several states, and without regard to any census or enumeration, which is, in a couple, the Federal Reserve was enacted in 1913 as well. That's when we got centralized banking, which is unconstitutional. I'm going to go ahead and pause this podcast, and you'll see me in the next version. It'll already be up. Thank you so much for listening, and don't forget to smile. Just going to quickly put this, let's see, what amendments did I read to? 16th, I don't really know. Just going to put 16. Figure it out later. Yeah, sorry about the delay. All righty. It's lagging, sorry. Like my phone case. I don't know why this is not working. It's there we go. Welcome back to the Zachary Gale Experience. Thank you so much for listening, and I will get right into it. Let's see if I can make the lighting a little better. Oh, that's much better. You can't see me now. All right. Let me know how that is if you prefer the other way. Actually, I can hardly see you. Sorry about that. Amendment, the 17th Amendment. Popular election of senators. 17th Amendment was proposed. I'm just going to try that. The 17th Amendment was proposed on May 13th, 1912, and ratified on April 8th, 1913. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election, as the legislature may direct. This amendment shall not be so constructed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. Okay. The 18th Amendment, Prohibition of Alcohol. The 18th Amendment was proposed on December 18, 1917, ratified on January 16, 1919, and was repealed by the 21st Amendment on December 5, 1933. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territory subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2 says, the Congress of the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3 says, this article shall be inoperative unless it shall have been ratified as an amendment of the Constitution by the legislatures of several states as provided in the Constitution within 7 years from the date of the submission hereof of the states by the Congress. Amendment 19, Women's Suffrage. The 19th Amendment was proposed on June 4th, 1919, and ratified on August 18th, 1920. The right of citizens of the United States to vote shall not be denied or obliged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. The 20th Amendment, Presidential and Congressional Term Limits. The 20th Amendment was proposed on March 2nd, 1930, as the terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of senators and representatives at noon on the 3rd day of January of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. Section 2 says, the Congress shall assemble at least once in every year, and in such meeting shall begin at noon on the 3rd day of January, unless they shall appoint a different day. Section 3 says, if at the time fixed for the beginning of the term of the President, the President-elect shall have died, Vice President-elect shall become President. If the President shall not have been chosen before the time fixed for the beginning of his term, or if the President-elect shall fail to qualify, then the Vice President-elect shall act as President until a President shall have qualified, and the Congress may by law provide for the case wherein neither a President nor President-elect nor The vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a president or vice president shall have qualified. Section 4 says the Congress may by law provide for the case of the death of any of the persons from whom House of Representatives may choose a president, whatever the right of choice shall have devolved upon them. And for the case of the death of any of the persons from whom the Senate may choose a vice president, whenever the rights of choice shall have devolved upon them. Section 5 of Amendment 20 says, Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6 says the article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the states, the several states within 7 years from the date of its submission. 21st Amendment. Repeal of alcohol prohibition. The 21st Amendment was proposed on January 20th, 1933 and ratified on December 5th, 1933. Excuse me. Section 1 says, the 18th article of amendment of the Constitution of the United States is hereby repealed. Section 2, the transportation or importation of any state, territory, possession of the United States for delivery or use therein of intoxicating liquors in violation of laws thereof is hereby prohibited. Article 3 says, this article shall be unoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the Constitution within 7 years from the date of the suspension hereof to the states by the Congress. 22nd Amendment, two-term limitation of presidency. The 22nd Amendment, gosh. The 22nd Amendment was proposed on March 24th, 1947, ratified February 27, 1951. Section 1 says, no person shall be elected to the office of the president more than twice, and no person who has held office of the president or acted as president for more than 2 years of a term to which some other person was elected, president shall be elected to the office of the president more than once. But this article shall not apply to any person holding the office of president when this article was proposed by the Congress, and shall not prevent any person who may be holding office in a president or acting as president during the term within which this article becomes operative from holding the office. The president or acting or office of president or acting as president during the remainder of such term. Section 2 says, the article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the day of its submission to the states by the Congress. Amendment 23, Suffrage and the District of Columbia, also known as Washington, D.C. It's its own separate state. The state meaning it has its own laws and whatnot. That's my personal thing. That's not in the Constitution. What the Constitution says, the 23rd Amendment was proposed on June 16, 1960, and ratified on March 29, 1961. Section 1 says the district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors, a president and vice president equal to the whole number of senators and representatives in Congress, in which the district would be entitled if there were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. Section 2 says the Congress shall have power to enforce this article by appropriate legislation. Amendment 24 says abolition of federal poll taxes. The 24th Amendment was proposed on August 27, 1962, and ratified on January 23, 1964. Section 1 says the right of citizens of the United States to vote in any primary or other election for United States or vice president for electors for president or vice president or for a senator or representative in Congress shall not be denied or bribed by the United States or any state by reason of failure to pay any poll tax or other tax. Section 2 says the Congress shall have power to enforce this article by appropriate legislation. Article 25, how many times am I going to do that? Amendment 25, I'm going to learn from my mistake. This is going to be the last time that happens. Amendment 25 says continuity of the presidency. The 25th Amendment was proposed on July 6, 1965, and ratified on February 10, 1967. Section 1 says, in case of the removal of the president from office or his death or resignation, the vice president shall become president. Section 2, whenever there is a vacancy in the office of vice president, the president shall nominate a vice president who shall take office upon confirming by a majority vote of both houses of Congress. Section 3 says, whenever the president transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives was his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the vice president as acting president. Section 4 says, whenever the vice president and a majority of either the principal officers and the executive departments of or of such other body of Congress may by law provide transmit to the president pro tempore of the Senate and the Speaker of the House of Representatives their written declarations that the president is unable to discharge the powers and duties of his office, the vice president shall immediately assume the powers and duties of thereafter. When the president transmits, excuse me, when the president transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives have a written declaration that no inability exists, he shall resume the powers and duties of his office unless the vice president and majority of either the principal officers of the executive department or of such other body as Congress may be law by provide transmit within 4 days of the president pro tempore of the Senate and the Speaker of the House of Representatives has written declaration that the president is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours of that propose, if not a session, if the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determined by 2/3 vote of both houses that the president is unable to discharge the powers and duties of his office, the vice president shall continue to discharge the same as acting president. Otherwise, the president shall resume the powers and duties of his office. Amendment 26, suffrage for 18-year-olds. Wow, I did not know this was an amendment. The 26th Amendment was proposed on March 23rd, 1971, ratified July 1st, 1971. Section 1 says, the right of citizens of the United States who are 18 years of age or older to vote shall not be denied or obliged by the United States or by any state on account of age. Section 2 says, the Congress shall have power to enforce this article by appropriate legislation. The 27th Amendment is limitation on congressional pay. The 27th Amendment was proposed on September 25th, 1789, and ratified May 7th, 1992. Oh, sorry for calling out the founders. In another one of my podcasts, I called them bastards for already trying to get pay increases, but they're actually trying to limitate pays, which, figures that's what they want to do because they're goats. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. Alrighty, that is the end of our amendments. I'm going to end the podcast here. The next one is going to be the Declaration of Independence. Thank you so much for listening, and I hope you enjoyed. Just titling it really quick. Alrighty, if you will just give me 30 seconds, I'm going to run into the other room, grab something to drink, and I will be back. If I'm not back within 20 seconds, feel free to leave. Alrighty, we are back. Hope that didn't take too long. Just give me a second to hydrate. So how's your day going? Hope it's going good. Hope it's going real good. Just give me uno momento. Whoa, what did I just do? Oh, alright. Alrighty, we're going to be reading the Declaration of Independence. Alright, we're good to go. Oh, I'm gonna just take another drink. And we are ready. Ready to go. Give me 1 second. Welcome back to the Zachary Gale Experience 369. Zach here, and we're going to be reading the Declaration of Independence. Let's get started. Declaration of Independence in Congress, July 4th, 1776. The unanimous Declaration of the 13 United States of America. When, in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth and separate an equal station to which the laws of nature and of nature's God entitle them, and decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, derive their just powers from the consent of the governed, that whatever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prejudice indeed will dictate that governments long established should not be changed for light and transient causes, and according all experience hath shewn that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations pursuing invariably that some object evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Such has been the patient suffrage of these colonies, and such is now the necessary which constrains them to alter their former system of government. The history of the present King of Britain is a history of repeated injuries and usurpations, all having in direct objection the establishment of an absolute tyranny over these states. To provide this, let facts be be submitted to a candid world. He has refused his assent to laws, the most wholesome and necessary for the public good. He has forbade his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained. And when so suspended, he has utterly neglected to attend to them. He has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the rights of representation in the legislature, a right inestimable to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and distant from the despotory of their public records, and for sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly for opposing with many firmness his invasions on the rights of the people. He has refused for a long time after such dissolutions to cause others to be elected, whereby the legislative powers incapable of annihilation have returned to the people at large for their exercise, the state remaining in the meantime exposed to all the dangers of invasion from without and convulsions within. He has endeavored to prevent the population of these states for the purpose of obstructing the laws of naturalization of foreigners, refusing to pass others to encourage their migrations hither, and raising the conditions of new appropriation of lands. He has obstructed the administration of justice by refusing to assent to laws for establishing judicial powers. He has made judges dependent on his will alone for the tenure of their offices and the amount of payment of their salaries. He has erected a multitude of new offices and sent hither swarms of offices to harass our people and eat at our so out. Excuse me, I lost my spot. Out their substance. He has kept among us in times of peace standing armies without the consent of our legislatures. He has affected to render the military independent of and superior of the civil power. He has combined with others to subject us to a jurisdiction foreign to our constitution and unacknowledged by our laws, giving his assent to their acts of pretend legislation, for quartering large bodies of armed troops among us, for protecting them by a mock trial from punishment for any murders which they should commit of our inhabitants of the states, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us, in many cases, of the benefits of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of English laws in our neighboring province, establishing therein an arbitrary government and enlarging its boundaries so as it to render it at an example and fit instruments for introducing the same absolute right rule of these colonies, for taking away our charters, abolishing our most valuable laws, and altering the forms of our governments, for suspending our own legislatures and declaring themselves invested with power to legislate us in all cases whatsoever. He has abdicated government. He has abdicated government here by declaring us out of his protection and waging war against us. He has plundered our seas, ravaged our coasts, burnt our towns, and destroyed the lives of our people. He is at this time transporting large armies of foreign mercenaries to complete the works of death, dissolution, and tyranny already begun, with the circumstances of cruelty and perfidy scarcely paralleled in the most barbarous ages, and totally unworthy of the head of a civilized nation. He has constrained our fellow citizens taken captive on the high seas to bear arms against their country, to become their executioners of their friends and brethren, or to fall themselves by their hands. He has excited domestic insurrections against us. He has endeavored to bring on the inhabitants of our frontiers the merciless Indian savages whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. In every stage of these oppressions, we have petitioned for redresses in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Nor have we been wanting in attention to our British brethren. We have warned them from time to time of attempts by the legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of the immigration and settlement here. We have appealed to their native justice and monogamy, and we have conjured them by the ties of our common kindred to disavow these usurpations which would inevitably interrupt our connections and correspondence. They too have been deaf to the voice of justice and of the cause anguinity. We must therefore acquiesce in the necessity which denounces our separation, and hold them, as we hold the rest of mankind, enemies in war, and peace friends. We thereof, the representatives of the United States of America in General Congress, assembled, appealing to the Supreme Judge of the world of the rectitude of our intentions due in the name and by authority and the good people of the colonies, solemnly publish and declare that the United Colonies are and of right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states they have full power to levy war, concede peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do. And of the support of this declaration, with firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our forfeitudes, and our sacred honor. Signers of the unanimous declaration, according to the authenticated list printed by the Order of Congress, January 18, 1777. From Georgia, Button Gwintent, Lyman Hall, George Walton. North Carolina, W.M. Hooper, Joseph Hughes, John Penn. South Carolina, Edward Rutledge, THOS Hayward Jr., Thomas Lynch Jr., Arthur Middleton. Massachusetts, John Hancock, Samuel Adams, John Adam, Robert Treat Payne, Elbridge Gerry. Maryland, Samuel Chase, W.M. Peka, THOS period Stone, Charles Carroll of Carrollton, Virginia, George Wythe, Henry Lee, TH period Jefferson, Thomas Jefferson, excuse me, Benjamin Harrison, THOS period Nelson Jr., Francis Lightfoot Lee, Carter Braxton, Pennsylvania, Robert Morris, Benjamin Rush, Benjamin Franklin, John Morton, George Clymer, J.S. period Smith, George Taylor, James Wilson, George Ross, Delaware, Caesar Rodney, George Reed, Thomas McKean, New York, William Floyd. I guess that's what WM stands for. So North Carolina is William Hooper, not WM. Phil Livingston, Francis Lewis, Lewis Morris, New Jersey, Richard Stockton, JNO period Witherspoon, FRIS period Hopkinson, John Hart, Abraham Clark, New Hampshire, Josiah Bartlett, William Whipple, Matthew Thornton, Rhode Island, Stephen Hopkins, STP period, William Ellery, Connecticut, Roger Sherman, Samuel Huntington, William Williams, Oliver Wolcott. And with that, I conclude this reading of the Declaration of Independence. Thank you. That was intense. I'm going to quickly save that and then start up another one because we're going to be reading the Articles of Confederation next. I almost forgot to start up another podcast. Welcome back to the Zachary Gale Experience 369. I'm going to be reading the Articles of Confederation now. To all to whom presents shall come, we are undersigned delegates of the states affixed to our names send greeting. Articles of Confederation and perpetual union between the states of New Hampshire, Massachusetts Bay, Rhode Island, and Providence, Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. Article 1 says, the style of this confederacy shall be the United States of America. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this confederation expressed delegated to the United States and Congress assembled. Article 3. The said states hereby severally enter into a firm league of friendship with each other for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all forces offered to or attacks made upon them of any of them on account of religion, sovereignty, trade, or any other pretense whatever. Article 4. The better to secure and perpetrate mutual friendship and intercourse among the people of the United States and the Union and free inhabitants of each of the states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens and the several states. Oh, it's accept. Wait. Yeah, it's accepted. Sorry, English is difficult sometimes. Shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress and regress to inform from any other state, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as the inhabitants thereof, respectively, provided that such restrictions shall not extend so far as to prevent the removal of property embattled into any state to any other state of which the owner is an inhabitant, provided also that no imposition, duties, or restriction shall be laid by the state on the property of the United States, either of them, if any person guilty of or charged with treason, felony, or other high misdemeanor in any state, shall flee from justice and be found in any of the United States, shall, upon demand of the governor or executive power of the United States, from which he fled, be delivered up and removed to the state having jurisdiction of his offense. Full faith and credit shall be given to each of these states to the records, acts, and judicial proceedings of the courts and magistrates of every other state. Article 5. For the most convenient management of the general interests of the United States, delegates shall be annually appointed in such manner as the legislations of each state shall direct to meet in the Congress of the first Monday in November in every year, with a power reserved to each state to recall its delegates, or any of them at any time within the year, and to send others in their stead for the remainder of the year. No state shall be represented in Congress by less than 2 nor more than 7 members, and no person shall be capable of being a delegate for more than 3 years and any term of 6 years, nor shall any person being a delegate be capable of holding any office under the United States for which he or another for his benefit receives any salary, fees, or an emolument of any kind. Each state shall maintain its own delegates in a meeting of the states, and while they act as members of the Committee of the States, in determining questions of the United States in Congress assembled, each state shall have 1 vote. Freedom of speech and debate in Congress shall not be impeached or questioned in any court or place out of Congress, and the members of Congress shall be protected in their persons from us or imprisonment during the time of their going to and from attendance on Congress, except for treason, felony, or breach of the peace. Article 6. No state without the consent of the United States and Congress assembled shall send any embassy to or receive any embassy from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state. Now shall any person holding any office of profit or trust under the United States or any of them accept any present emolument, office, or title of any kind whatever from any king, prince, or foreign state, nor shall the United States in Congress assembled or any of them grant any title of nobility. No 2 or more states shall enter into the treaty, confederation, or alliance, whatever between them, without the consent of the United States in Congress assembled. Specify accurately the purposes for which the same is to be entered into and how long it shall continue. No state shall lay any imposts or duties which may interfere with any stipulations and treaties entered into by the United States in Congress assembled with any king, prince, or state in pursuance of any treaties already proposed by Congress to the courts of France and Spain. I just want to read that little section in my head. Okay. No vessel of war shall be kept up in time of peace by any state, except such number only as shall be deemed necessary by the United States and Congress assembled for the defense of such state or its trade, nor shall any body or forces be kept up by any state in time of peace, except number only as in the judgment of the United States and Congress assembled shall be deemed requisite to garrison the forts necessary for the defense of such state. But every state shall always keep a well-regulated and disciplined militia sufficiently armed and accoutred, and shall provide and constantly have ready for use in public stores a due number of filed pieces and tents, and a proper quantity of arms, ammunition, and camp equipage. No state shall engage in any war without the consent of the United States and Congress assembled, unless such state is actually invaded by enemies, or shall have received certain advice by a resolution of being formed by some nation of Indians to invade such state, and the danger is so imminent as not to admit of a delay until the United States Congress assembled can be consulted, nor shall any state grant commissions to any ship or vessel of war, nor letters of marque or reprisal, except it be a declaration of war by the United States and Congress assembled, and then only against the 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 kingdom or state and the subjects thereof, which war has been so declared, and under the such regulations as such shall be established by the United States and Congress assembled, unless such state is infested by pirates, in which case vessels of war may be fitted out for that occasion and kept so long as the danger shall continue, or the United States and Congress assembled shall determine otherwise. Article 7. When land forces are raised by any state for the common defense, all officers of or under the rank of colonel shall be appointed by the legislature of each state respectively, by whom such forces shall be raised, or in such manner as such state directs, and all vacancies shall be filled by the state which first made the appointment. Article 8. All charges of war and all their expenses that shall be incurred for the common defense, or general welfare, again, and allowed by the United States and Congress assembled shall be defrayed out of a common treasury, which shall be supplied by the several states in proportion to the value of all land within each state, granted or surveyed from any person, as such land and the buildings and improvements thereon shall be estimated according to such mode as the United States and Congress assembled shall from time to time direct and appoint. The taxes for paying the appropriation shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States and Congress assembled. Article 9. The United States and Congress assembled shall have the sole and exclusive power and right to determining on peace and war, except in the cases mentioned in the 6th article, or sending and receiving ambassadors, entering into treaties and alliances, provided that no treaty of commerce shall be made whereby the legislative power of respective states shall be restrained from imposing such imposts and duties on foreigners as their own people are subject to, or from prohibiting the exportation and importation of any species of goods or commodities whatsoever, or establishing rules or deciding in all cases what captures on land or water shall be legal, and what manner prizes taken by land or naval forces in the service of the United States shall be divided or appropriated. And of granting letters of marque and reprisal in times of peace, appointing courts for the trial of piracies and felons committed on the high seas, and establishing courts for receiving and determining finally appeals in all cases of captures, providing that no member of Congress shall be provided that no member of Congress shall be appointed a judge of any of the said courts. The United States of America the United States and Congress assembled shall also be the last resort on appeal and all disputes and differences now subsiding that hereafter may arise between two or more states concerning boundary, jurisdiction, or any other causes whatever, which authority shall always be exercised in the manner following. Whenever the legislative or executive authority or lawful agent of any state in controversy with another shall present a petition to Congress stating the matter in question and praying for a hearing, notice thereof shall be given by order of Congress to the legislative or executive authority of the other state in controversy, and a day assigned for the appearance of the parties by their lawful agents. Who shall then be directed to appoint by joint consent commissioners or judges to constitute a court for hearing and determining the matter in question. But if they cannot agree, Congress shall name 3 persons out of each of the United States, and from the list of such persons, each party shall alternately strike out one, the petitioners being until the number shall be reduced to 13, and from that number not less than 7, nor more than 9 names of Congress shall in the presence of Congress be drawn out by lot, and the persons whose names shall be drawn, or any 5 of them, shall be commissioners or judges to hear and finally determine the controversy. So always as a major part of the judges who shall hear the cause shall agree in the determination. And if either party shall neglect to attend to the day appointed without showing reasons, which Congress shall judge sufficient, or being present shall refuse to strike, the Congress shall proceed to nominate 3 persons out of each state, and the Secretary of Congress shall strike in behalf of such party absent or refusing, and the judgment and sentence of the court to be appointed in a manner before prescribed shall be final and conclusive. And if any of the parties shall refuse to submit the authority of such courts or to appear or defend their claim or cause, the court shall nevertheless proceed to pronounce sentence or judgment, which shall in like manner be final and decisive. The judgment or sentence and proceedings being in either case transmitted to Congress and lodged among the acts of Congress for the security of the parties concerned, provided that every commissioner before he sits in judgment shall take an oath to be administered by one of the judges of the Supreme or Superior Court of the state where the cause shall be tried, well and truly to hear and determine the matter in question according to the best of his judgment, without favor, affection, or hope or reward, provided also that no state shall be deprived of territory for the benefit of the United States. All controversies concerning the private right of soil claimed under different grants of 2 or more states, whose jurisdiction as they may respect such lands, and the states which pass such grants are adjusted, the said grants, or either of them being at the same time claimed to have originated antecedent to such settlements of jurisdiction, shall, on the petition of either party of the Congress of the United States, be finally determined as near as may be in the same manner as is before prescribed for deciding disputes respecting territorial jurisdiction between different states. The United States and Congress assembled shall also have the sole and exclusive right and power of regulating the alloy and value of coin struck by their own authority, and by that of the respective states, fixing the standards, weights, and measures throughout the United States, regulating the trade and managing all affairs with the Indians, not members of the states, prohibited that the legislative right of any state within its own limits not be infringed or violated, establishing the right of post offices from one state to another throughout all the United States, and exacting such postage on the papers passing through the same as may may be the requisite to defray the expenses of the said office. Appointing all officers of the land forces in the service of the United States, excepting regimental officers, appointing all the officers of the naval forces, and the commissioning all officers, whatever, in the service of the United States, making rules for the government and regulation of the said land and naval forces and directing their operations. The United States and Congress assembled shall have authority to appoint a committee to sit in recess of Congress and to be denominated a committee of the states and to consist of one delegate from each state and to appoint such other committees and civil officers that may be necessary for managing the general affairs of the United States under their direction. To appoint one of their members to provide that no person be allowed to serve in the office of president more than 1 year in any term of 3 years, to ascertain the necessary sums of money to be raised for the service of the United States and to appropriate and apply the same for defraying the public expenses, to borrow money, to emit bills on the credit of the United States, transmitting every half year to the respective states an account of the sums of money so borrowed or emitted, to build and equip a navy, to agree upon the number of land forces, and to make requisitions from each state for its quota, in proportion to the number of white inhabitants in such state, which requisition shall be binding, and thereof the legislature of each state shall appoint the regimental officers, raise the men, and clothe, arm, and equip them in a solid like manner, the expense of the United States, and the officers and men so clothed, armed, and equipped shall march to the place appointed, and within the time agreed by the United States and Congress assembled. But if the United States and Congress assembled shall, on the consideration of circumstances, judge proper that any state should not raise men, or should raise a smaller number of men than the quota thereof, such extra number shall be raised, officered, clothed, armed, and equipped in the same manner as the quota of each state, unless the legislature of each state shall judge that such extra number cannot be safely spread out in the same, in which case they shall raise, officer, clothe, arm, and equip as many of such extra as the judge can be safely spared. And the officers and men so clothed, armed, and equipped shall march to the place appointed and within the time agreed by the United States and Congress assembled. The United States and Congress assembled shall never engage in a war, nor grant letters of marque or appraisal in time of peace, nor enter into any treaties or alliances, nor coin money, nor regulate the value thereof, nor ascertain the sums and expenses necessary for the defense and welfare of the United States, or any of them, nor emit bills, nor borrow money on the credit of the United States, nor appropriate money, nor agree upon the number of vessels awarded to be built or purchased, or the number of land or sea forces to be raised, nor appoint a commander-in-chief of the Army or Navy, unless the United States assent to the same, nor shall a question on any other point, except for adjourning from day to day, be determined unless by the votes of the majority of the United States in Congress assembled. The Congress of the United States shall have the power to adjourn to any time within the year, and to place within the United States, so that no period of adjournment be for a longer duration than the space of 6 months, and shall publish the journal of the proceedings monthly, except such parts thereof relating to treaties, alliances, or military operations as in their judgment require secrecy, and the yeas and nays of the delegation each state on any question shall be entered on the journal when it is desired by any delegate of the state or any of them at his or their request shall be furnished with a transcript of the said journal, except which parts as are above expected, to lay before the legislatures of several states. And I'm going to go ahead and cut the podcast off here. Come back for Article 10. Thank you so much for listening. Just give me 1 second. Alrighty. Thank you for being patient. I'm just going to drink some more of my drink. Let me stretch really quick. All right, I'm about ready. Only a couple more pages left, but then there is a page that says American Constitution History, a Precis. Alrighty. Episode of Adventure Time. And it looks like I'm about to go like sign the Declaration of Independence at 6 and then try to steal the Declaration at 8. All right. Welcome back to the Zachary Yale Experience, 369. Zach here. Starting off with Article 10 of the Articles of Confederation. Let's dive into it. The Committee of the States, or any 9 of them, shall be authorized to execute in the recess of Congress such of the powers of Congress as the United States in Congress assembled by the consent of the 9 states shall from time to time think expedient to vest them with, provided that no power be delegated to the said committee for the exercise of which by the Articles of Confederation the voice of 9 states in the Congress of the United States assembled be requisite. Article 11. Canada acceding to this confederation and adjoining in the measures of the United States shall be admitted onto and entitled to all the advantages of this union, but no other colony shall be admitted into the same unless such admission be agreed by the 9 states. Article 12. All bills of credit emitted, moneys borrowed, and debts contracted by or under the authority of Congress before the Assembly of the United States in pursuance of the persistent Confederation shall be deemed and considered as a charge against the United States, for payment and satisfaction whereof the said United States and public faith are hereby solemnly pledged. Article 13. Every state shall abide by the determination of the United States in Congress assembled on all questions which by this confederation are submitted to them. And the articles of this confederation shall be inviolably observed by every state, and the Union shall be perpetual, nor shall any alteration of any time hereafter be made in any of them. unless such alteration be agreed to in a Congress of the United States and be afterwards confirmed by the legislatures of every state. And whereas it hath pleased the great governor of the world to incline the hearts of the legislatures with respective represent in Congress to approve of and to authorize us to ratify the said Articles of Confederation in perpetual union. Know ye that we, the undersigned delegates, by virtue of the power and authority to us given for that purpose, do by the presence in the name and in behalf of our respective constituents, fully and entirely ratify and confirm each and every of the said Articles of Confederation and perpetual union, and all in singular the matters, the things therein contained. And we do further solemnly plight and engage the faith of our respective constituents that they shall abide by the determination of the United States and Congress assembled on all questions which by the said confederation are assembled to them, and that the articles thereof shall be inviolably observed by the states we respectively represent, and that the union shall be perpetual. In witness thereof, we have hereunto sets our hands in Congress done at Philadelphia in the state of Pennsylvania on the 9th day of July in the year of our Lord 1778, and in the third year of our independence of America. They so that's the Articles of Confederation, the last bit. So this Constitution that's from Young Americans for Liberty, they have a page afterward that says they can't push this around forever. The following is a letter from Tennessee to the other 49 state legislatures, written by Representative Susan Lynn, Tennessee 57th District. We send greetings from the Tennessee General Assembly on June 23rd, 2009, House Joint Resolution 108. The state sovereignty resolution was signed by Governor Phil Broodsing. The resolution created a committee which has as its charge to communicate the resolution to the legislators of the several states, assure them that this state continues in the same esteem of their friendship, call for a joint working group between the states to enumerate the abuses of authority by the federal government, and seek repeal of the assumption of powers and the imposed mandates. It is for those purposes that this letter addresses your honorable body. In 1776, our founding fathers declared our freedom in the magnificent Declaration of Independence. Our guide to governance, they established a nation of free and independent states, declaring that the purpose of our political system is to secure for its citizens their natural rights. The Constitution authorizes the national government to carry out 17 enumerated powers in Article 1, Section 8, and the powers of the several of the ensuing amendments. At the time of the constitutional ratification process, James Madison drafted the Virginia Plan to give Congress general legislative authority and to empower the national judiciary to hear any case that might cause friction among the states, and to give the Congress a veto over state laws, to empower the national government to use the military against the states, and to eliminate the states' accustomed role in selecting members of Congress. Each one of these proposals was soundly defeated. In fact, Madison made more attempts to authorize a national veto over state laws, and these were repeatedly defeated as well. There are clear limits to the power of the federal government and clear realms of power of the states. However, the simple and clear expression of purpose to secure our national rights has evolved into the modern expectation that the national government has a obligation to ensure our life, to create our liberty, and to fund our pursuit of happiness. The national government has become a complex system of programs where purposes lie outside of the responsibilities of enumerated powers and of securing our national rights programs that benefit some while others must pay. Today, the federal government seeks to control the salaries of those employed by private businesses, to change the provisions of contracts, to nationalize banks, insurers, and auto manufacturers, and to dictate every person in the land what his or her medical choices will be. Forcing property from employment to provide health care. Legislatures and individuals are not entitled to, and using the labor of some so that they can receive money that they did not earn goes far beyond securing national rights and the enumerated powers in the Constitution. The role of our American government has been blurred, bent, and breached. The rights endowed to us by our Creator must be restored. To be sure, the people who created the federal government to be their agent for certain enumerated purposes only. The constitutional ratifying structure was created so it would be clear that it was people, not the states, that were doing the ratifying. The 10th Amendment defines the total scope of federal power as being that which has been delegated by the people to the federal government, and is also that which is absolutely necessary to advancing those powers specifically enumerated in the Constitution of the United States. The rest is to be handled by the state governments or locally by the people themselves. The Constitution does not include a congressional power to override state laws. It does not give the judicial branch unlimited jurisdiction over all matters. It does not provide Congress with the power to legislate over everything. This is verified by the simple fact that attempts to make these principles part of the Constitution were soundly rejected by its signers. With this in mind, any federal attempt to legislate beyond the constitutional limits of Congress's authority is an usurpation of state sovereignty and unconstitutional. Governments and political leaders are best held accountable to the will of the people when government is local. The people of a state know what is best for them. Authorities potentially thousands of miles away governing their lives is opposed to the very notion of freedom. We invite your state to join with us to form a joint working group between the states to enumerate the abuses of authority by the federal government and to seek repeal of the assumption of powers and the imposed mandates. Editor's note. Since the creation of the committee stated above, Tennessee has enacted the Firearms for Freedom Act. The Tennessee FFA states, federal laws and regulations do not apply to personal firearms, firearms, accessories, or ammunition that is manufactured in Tennessee or remains in Tennessee. The limitation on federal law and regulation stated in this bill applies to a firearm accessory, or ammunition that is manufactured using basic materials that can be manufactured without the inclusion of any significant parts imported into the state. However, the Bureau of Alcohol, Tobacco, Firearms, and Explosives has contested this law, citing federal law supremacy over state law. Wow, that's not cool. I'm going to go ahead and end this podcast here, and I'm going to have one more part where I read the American Constitution history. Thank you so much for listening, and thank you for listening as well. You're awesome. Give me 1 second. All right, we are about done. Waiting for the load. Okay. Welcome back to the Zachary Gale Experience 369. I'm your host, and we're going to be reading the American Constitutional History from the same Constitution provided by Young Americans for Liberty that was provided to me at some point in time. So the American Constitutional History, a Precis by Kevin Gutzman. At the Philadelphia Convention on May to September 1787 that wrote the U.S. Constitution, the delegates had every opportunity to reject the decentralized Republican policies for which the Revolution had been won only 4 years before. The new Confederation, created under the recently ratified Articles of Confederation, was already starting to show its own shortcomings. Some saw this as a failure of federalism and called it for a national government to be created. Parentheses, in a federal system, the parts come first and create the center, while in a national system, the center takes priority and doles out responsibility to the parts. However, when James Madison of Virginia proposed a national rather than federal plan of government to that body, he found little support. The Virginia plan, as it became known, contemplated a national government with a general legislative power for the national legislature, jurisdiction over all important cases for the national judiciary, popular election of congressmen in place of state popular election of congressmen in place of state legislative election of congressmen, population apportionment of both legislative houses instead of an equal vote for each state. With a national veto over all state laws, the proposal, as Madison said, that most important, all of these proposals were rejected. During the ratification campaign of 1787 to 1790, the Federalists, in an attempt to ease tensions, argued that the new Constitution would create a federal government, not a national one. Congress would have only the powers expressly delegated. Leading federal spokesman in the Virginia Ratification Convention even promised that Virginia could reclaim the powers it was granting the federal government in case that those powers were abused. In other words, Virginians ratified on condition that they could succeed. New Yorkers and Rhode Islanders made similar reservations. Although Federalists made these promises, their opponents, whom Federalists called anti-federalists, insisted that Congress would lay claim to powers not spelled out in the Constitution, that federal courts would claim jurisdiction not provided by the Constitution, and that the omission of a Bill of Rights assured ill. Their chief contention was that before the new charter was ratified, it should be amended. The anti-federalists succeeded, winning public insistence on it. The Federalist acquaintances in adoption of the first 10 amendments, which became known as the Bill of Rights. The preamble to the Bill of Rights made clear that the purpose of the proposed amendments was to mollify those who thought that the Constitution was dangerous by further defining the limits of federal power. From the beginning, all three branches grabbed at additional power. The Supreme Court's attempt to do so in Chisholm versus Georgia, 1793, yielded the 11th Amendment within 2 years. In fact, the 1790s saw the birth of two parties in federal politics. One nationalist, the Federalists, and the other Federalists, the Republicans. At the end of the decade, the Federalists were voted out of power. Within 20 years, the party virtually ceased to exist. Americans still favored the Revolution's federal constitutional model over George III's national approach. Yet, even as the final Federalist president was voted out of office, he appointed a Federalist Chief Justice, John Marshall. Marshall would write several Supreme Court opinions exceeding federal power well beyond the confines of the written Constitution. In McCulloch versus Maryland, 1891, for example, Marshall laid out a virtually unbounded approach to congressional power under the necessary and proper clause. James Madison rightly noted that had the people known that this way the Constitution would be interpreted, they would never have ratified it. In Gibbons v. Ogden, 1824, Marshall worked similar centralizing magic with the Commerce Clause, and Martin versus Hunter's lease, 1816. Found the court holding that had the right to review state Supreme Court's decisions, even though Marshall's party had been consigned by the voters to be the ash heap of history. Constitutional law was the route taken by men that had discredited party to victory in the Constitutional War. American constitutional history shifted dramatically again during the Civil War. The Rump Union's Congress decided to grant President Abraham Lincoln's claims to virtually unlimited power in wartime. Not only suppression of the states' rights reserved to secede from the Union, but also conscription, paper money, presidential suspension of the writ of habeas corpus, and open presidential flouting of federal courts. Decisions were among the nationalistic innovations of those years. Lincoln claimed inherent authority to do some of those things regardless of the law. At the war's end, 3 new amendments empowering the federal government were added to the Constitution. The Republican majority in Congress intended to remake the South permanently through these amendments. How? In the case of the 14th, several southern states were told that their military occupation would continue until they ratified it. No one had offered a persuasive explanation how ratification in such circumstances can be said to have been voluntary, thus valid. The ends justified the means. Those amendments permanently eliminated slavery from the American landscape, guaranteed the equal protection due process of law would be provided by state governments, banned the southern states from paying the debts that had incurred during the Civil War, and barred the states from denying the vote on the bias of race. The last provision was essentially unenforced for most of a century. The period between Reconstruction's end in 1877 and the Revolution of 1837 saw a growing nationalist ferment. Amendments were added empowering Congress to establish an income tax and giving the people of each state, rather than the state legislature's power to elect U.S. senators. At the same time, the Supreme Court was carving out huge swaths of economic policymaking as its own preserve. Under the 10th Amendment and the Doctrine, lost my spot. Under the 10th Amendment and the Doctrine of Liberty of Contract, it said that the federal government and the states were all banned from regulating wages, hours, working conditions, and terms of employment. The liberty of contract doctrine had no basis in the Constitution. In 1937, the court abruptly threw out the liberty of contract doctrine that had curbed state economic legislation and ceded to enforce 10th Amendment limitation on congressional power. From 1837 to 1995, it did not hold a single congressional statute unconstitutional. Instead, it imposed a plethora of limitations on state authority without any basis in the Constitution. Among the areas of state policy making the federal courts now oversaw were criminal procedure, criminal punishment, legislative apportionment, sex, abortion, assignment of students to public schools, mention of or illusion of God in any government context, and numerous others. Today, the USA has a national government despite the federal constitution. Congress exercises essentially unlimited powers, and federal judges commonly veto state laws on the basis of spurious doctrines supposedly based on the 14th Amendment mandate that the states afford accused criminals due process of law. Presidents claim inherent authority both domestically and overseas. In wartime, the 10th Amendment, which Jefferson said stated the underlying theory of the Constitution. Kevin R.C. Guzman, J.D., Ph.D., and Associate Professor of History at Western Connecticut State University, is the author of The Politically Incorrect Guide of the Constitution and Virginia's American Revolution from Dominion to Republic, 1876 to 1840. He also is the co-author of William E. Woods Jr., Thomas E. Woods Jr. of Who Killed the Constitution, the Federal Government versus American Liberty from World War I to Barack Obama. The Constitution, a brief bibliography. So it just states where the sources come from. Campaign for Liberty, the online Library of Liberty Library of Constitution Classics. Those are internet works. Primary works is The Federalist of Polybius, Alexander Hamilton, John Jay, and James Madison. And the Anti-Federalist Papers, edited by Ralph Ketchum. Secondary works are Original Intentions on Making and Ratification of the United States Constitution and Defense of the Constitution, George Carey. The Politically Incorrect Guide to the Constitution, Novus Ordo Seclorum, The Intellectual Origins of the Constitution, Freedom and Federalism, The Constitution and Exile, and that's it. Thank you so much for listening. See you in the next podcast. And thank you so much for everybody that's watched this either live or some other point in time in the present. Really appreciate you. It's become a very awesome time to be alive. Well, it's always an awesome time to be alive. I don't know what I meant by that. It's definitely a great time to be somebody who cares about our country. If you would like me to talk about anything else, I can talk about the Constitution today or something. I'm kind of a little bit worn out. I have been standing a lot of today, but regardless, I will still, if you want me to talk about something, anything, I will. Feel free to leave a comment if you would wish me to speak about something. No, it's perfectly okay. I don't want to make anybody do anything that they don't want to do. But here's my pins I'm wearing. Yay for QA and taxation and stuff. I'll give you a couple minutes to decide if you want me to talk about anything. Well, I somewhat stretch. Oh boy. Well, I think I'm just going to end it there. Well, I don't think I know I'm going to end it there. Thank you so much for listening. If you are new to the channel, watching this not live, thank you for watching. I hope you had as much fun as I did. Don't forget to leave a like, comment, subscribe. It's really important. It shows me that you like content like this and you want to see more constitutional stuff, maybe some more interpretations in the future, why taxation is theft, that sort of thing. And yeah, Everybody wins. You get some great content, and I get acknowledgement that people like what I do. As always, smile. Have a great day or night, technically.